Washington is now in session.
Good morning. Please be seated. Welcome to the Washington Supreme Court. Today is November 3rd of 2022, the final oral argument day of this term. We're hearing two cases here in the Cherbourg building while our Temple of Justice is being renovated and until our temporary space in Tumwater is complete. First of the two cases today is in re the dependency of AC. Opening for the parents is first Jared Berkeley Steed for 7 minutes, Lisa Elner for 7 minutes. Then a response from Lauren Danskine, 20 minutes, with 6 minutes reserved for rebuttal. Counsel, you may proceed.
May it please the court, Jared Steed appearing on behalf of the petitioner father. Your Honors, it is undisputed that the trial court improperly relied on hearsay as a basis for entering the dependency, disposition, and out-of-home placement orders in this case. The question then is whether the court's reliance on this inadmissible hearsay was harmless. Because the answer is no, we ask this court to reverse the dependency, dispositional, and out-of-home placement orders.
Would that practically result if we agreed with you in a remand for a new hearing, or just practically result if we agreed with you in a remand for a new hearing, or just vacating the order?
I think the order needs
them started all over with a different petition with allegations.
I think the dependency and the remaining orders need to be reversed outright, Your Honor, and started over. The problem here is simply that, you know, the proper test is whether the admitted hearsay, the Court of Appeals did not apply that standard.
I'm sorry, triviality is the test?
Well, yes.
The error has to be trivial?
Trivial and only of minor significance in relation to the evidence as a whole, yes, Your Honor.
Can you tell me which case, what you're quoting from?
That would be Estes, Your Honor, as well as Gower.
Can you tell me which case, what you're quoting from?
That would be Estes, Your Honor, as well.
When I read the briefing, there's a lot of discussion around the so-called substantial evidence test. The parties talk. When I read the briefing, there's a lot of discussion around the so-called substantial evidence test. Do the parties disagree about the standard for assessing whether an error is harmless? Do the parties disagree about the standard for assessing whether an error is harmless error?
I think insofar, Your Honor, as the argument is that the proper test here is, what we're contending is that the test is not a sufficiency test. So this court does not examine whether the remaining admissible evidence is sufficient. The test is whether the erroneously admitted hearsay in no way affected the outcome. And the analysis of that is whether it was trivial and only of minor significance.
I want to follow up on Justice Stevens' questions because I think this is, does the standard by which the finding was required at the trial court affect the preponderance of the evidence? Does the standard by which the finding was required at the trial court constitutional harmless error analysis? Is it material evidence? Do we consider the prejudice, or do we only get to prejudice after making the initial finding about the nature of the error? Please help me.
Yeah, absolutely, Your Honor. That's a great question. So again, I think that this court does need to address that issue, and I think we are at that point because there's no dispute here that the admission of the hearsay was improper. So we are at the prejudice analysis. As to Your Honor's question about what is the proper standard here,
do we get to prejudice if we first say, if we do the sufficiency analysis?
Standard here.
Do we get to prejudice if we first say, if we do the?
I'm not arguing that there is no sufficiency analysis. I'm arguing that that is not the proper analysis for harmless error. That is a separate analysis. This court can certainly undertake a sufficiency analysis and find that this evidence itself is not sufficient. But in light of, even if that test is not analysis and find that this evidence itself is not sufficient. But in light of, even if that is, you know, whether the remaining evidence when the hearsay is removed is not satisfied, then this court needs to engage in a harmless error.
I'm not sure I heard that clearly enough.
Okay.
If we remove the hearsay and what we have left
to engage in a harmless error.
I'm not sure I heard that clearly enough.
Okay.
If we remove the hearsay and the hearsay was so bad that despite there being sufficient evidence, you overturn what happened below.
Your Honor, as we've argued in the in the supplemental briefing, the question, if you get to that harmless error analysis and you remove the hearsay, the standard is what constitutes a reasonable probability that the outcome of trial was materially affected. And as this court has noted in Estes, reasonable probability is a lower standard than preponderance of the evidence.
And I'm just piling on here, and I apologize for that. But the other thing I want to ask you about is often experts rely on hearsay to explain their position or their view. And that's allowed, but it can't be considered for the truth, but to explain the analysis. Can the parties use the hearsay that comes in through an expert that way to ask questions of the parties? In other words, if there's hearsay that there was DV, can they, judge or one of the attorneys, then ask the witness when they testify, based on that hearsay, would you tell me whether that happened? And would that evidence then be admissible?
Well, I think to the extent that Your Honor asked whether that happened, no, because that would be an opinion as to something that the expert witness did not observe, right? That's hearsay. So they're relying on their expert analysis, their expert basis to offer an opinion as to still what they've personally witnessed or what they've personally heard. I don't think that the rules ER 703 and 705 allow this court to usurp that and say, well, this is an expert witness, and so here's the hearsay that I've relied on, and therefore I believe that that hearsay, supports my opinion that this did in fact happen.
Can I jump in and say, I guess I thought part of the question was, the expert has testified, permissibly relying on hearsay as a basis of an opinion. A fair question counsel might ask of a party is, the expert says this is the situation when this particular fact occurs. Did that fact occur? That's what I heard the chief partly ask.
Okay.
What's your answer to that question? Can they be asked that?
I think they can be asked that, but then that cannot be used as substantive evidence.
Their answer to that could not be used as substantive evidence?
Their answer to, basing an opinion on hearsay cannot be used as substantive evidence, no, because that usurps the credibility determination and undermines the rules of evidence and the statutory rules that make clear that the rules of evidence do apply at dependency hearings. If an expert witness could simply make clear that the rules of evidence do apply at dependency hearings. If an expert witness, I'm going to, in my expert opinion, deduce that this did in fact happen, then that undermines the rules, that undermines the purpose behind the rules.
Counsel, let me ask you a question about the harmlessness test before your time ends. I think you answered a couple of the questions earlier by saying, if you reach the question of harmless error, how can we not reach the question of harmless error? Don't we have an acknowledged error in admission of hearsay? And doesn't the whole case hinge on how we decide what happens after that?
I see I'm out of time. If I can just answer that question briefly, Your Honor. The answer is yes. So the question, as I understood it, was, can we reverse this dependency based on an insufficient evidence? Yes, you can do that. If, however—
I'm not asking about insufficiency of the evidence. I'm asking about prejudice versus harmless error. And you said, if you reach the question of harmlessness.
And to the extent that my answer to that was unclear, I was referring to the sufficiency. But if this court— and to the extent that my answer to that was unclear, I was referring to the sufficiency. But if this court— our response is that that standard is not a sufficiency test, but what constitutes a reasonable probability, which is whether the admitted hearsay was trivial and only of minor significance in reference to the evidence as a whole. Thank you.
Thank you, counsel. Additional presentation, please.
Good morning. Lisa Elmer on behalf of the mother, CCCP, and Ray the Welfare of AC. So I largely agree.
Let me ask you to lower the microphone.
Yeah, you bet. I think that this court does need to decide harmless error and prejudice and address how sufficiency plays a role in that. I agree that the test is, with the admissible evidence, is there a reasonable probability that it affected the outcome of the trial? If it did, then you have prejudice. I think, though, in finding prejudice, you have to look at, was there redundancy in admissible evidence so that you have a harmless error?
I asked counsel whether there's going to be a difference based on what the standard of evidence is at trial and I'm not sure I heard a clear answer. If it's the termination hearing, it's clear, cogent, and convincing evidence. If it's
Right.
dependency, it's by a preponderance.
That's right.
On review, does it matter which one we're reviewing in terms of the standard that we apply?
I don't think so. I mean, the lowest burden is by a preponderance and harmless error. And in this case, the state couldn't meet those burdens. You know, they're real standards, as low as they are. The state has to present admissible evidence in order to support, for the court to support an order of dependency, findings and conclusions. In this case, the court simply did not. If you look at the Court of Appeals opinion, the trial court's rulings, the state's briefing, they all point to inadmissible hearsay to find my client unable to safely parent under a 6C dependency. There's nothing, any way you look at this case, it's a little bit different for my client, because whether you apply a sufficiency, whether you apply harmless error here, the evidence does not exist to establish by a preponderance. The evidence that exists relates to the father, or there's no nexus between the court's concerns with the mother's parenting skills, or the evidence actually supports all of the Court of Appeals concerns. The one witness, Logan Wright, testified the mother attends to the baby. She learned to understand the cues. She safely holds the baby. She attends every visit consistently on her own without the father. She attends feeding. She attends all the medical. There was nothing to indicate any developmental delays. There was nothing to indicate mental health other than the state pointed out she goes to counseling. So if going to therapy was, grounds to not be able to safely parent, a lot of us would be in trouble. They also point to the...
Counsel, wasn't some of the concern based on the relationship between your client and the father, and him being controlling and not allowing her to speak in front, without him present, about whatever their situation might be, and that might impact whether or not she could protect her child when it came to, and that might impact whether or not she could protect her child when it came.
Mom hung up the phone to talk to the CPS worker. Mom came to visits without the husband. Evidence demonstrated mom hung up the phone to talk to the CPS worker. Mom came to visits without the husband. Mom attended parenting class without the husband. The McAllister, the LDS bishop, said he's loud, he's passionate, he doesn't control her. Mom said he doesn't hurt me emotionally or physically. I am not afraid of him. That's the admissible evidence. So about if the state's attorney asked a parent about information that came through hearsay, like ask the mother, do you experience domestic violence? Hearsay, like ask the mother, do you experience domestic violence? I think that's a fair question that she gets to answer. Or ask the father, I think that's different. And whether that's a backdoor bootstrapping, I don't believe so. In this case, that wasn't done, or the questions that were answered, the mother said, no, I am not afraid of this man. He doesn't harm me. The inadmissible evidence came from her methamphetamine addiction.
Then it sounds to me like under any standard that the court might use, you think that the evidence is just insufficient, or court might use, you think that the evidence is just insufficient, or
Admissible evidence affect the outcome. In this case,
well, that's your assertion.
Yes,
to the standard.
and under that standard, the evidence drove and directed the outcome. It didn't just affect it. And under that standard, the evidence drove and directed the outcome. It didn't just affect it. Because if you take that away, there's nothing left.
Could I ask you, this is a civil case, right?
Yes.
Is there a difference between the standard when there's error in a civil case and the standard that we apply when this is a criminal case.
Well, the parents have, I think Santosky stands for you have a fundamental constitutional right to parent your children.
Well, that's true, counsel.
And
but
so-
at this level, aren't we with a preponderance of the evidence standard, which would suggest we're not dealing with a constitutional right at this juncture?
No, I think the right to parent begins when you give birth and you have, or you adopt a child, you have a baby, you have a right. It's not dependent on how the state proceeds. And you give birth and you have, or you adopt a child, you have a baby, you have a right. It's not dependent on how the state proceeds against you. It's
So
inherent.
why would we have a preponderance standard at a dependency?
Because of
rather than-
the permanency, it doesn't, in my opinion, it doesn't affect the right to parent, but it's the permanency. Dependency, your rights aren't forever severed. You're given an opportunity to rehabilitate where the need exists. So I find those distinct from the inherent right, fundamental right to parent. Does that answer your question?
Well, yes and no. We're talking about procedure here, right? And the standard that we would apply when the evidence is insufficient or
Right.
when it's, there's been error in admitting evidence.
Right.
And since we are at the point, as one could use in the justice system,
Right.
I guess I'm still interested in your response to the question of whether there's a difference, because I guess I'm still interested in your response to the question of whether there's a difference, because in civil cases, we do have a different analysis when there's an error than when we have an error in a criminal trial. And rather than hanging this on the Constitution, I would like to just have an answer with respect to civil versus criminal.
Right. I can't address generically civil. In parental rights cases, you have a fundamental right to parent. So my position is they're the same as in a criminal case. This is fundamental, that there is not a distinct standard, a different approach. That harmless error, you have a preponderance of evidence. The state has to meet that burden in a dependency. It's a real burden. It's not a flip of the coin. They actually have to demonstrate with admissible evidence that it's more probable than not. And they haven't met that burden. That's the burden in this case. So harmless error, I think XT in this court has addressed an MR recently that when you have evidentiary reveal, did it have a reasonable probability of impacting the outcome? So,
And yet, many dependency cases also use the sufficiency of the evidence standard to measure whether or not, and yet, many dependency cases also use the sufficiency of the evidence standard to measure whether or not the error is reversible.
Right.
And that's really what it's about.
and on in my client's case, I agree, it makes no difference.
That was where we started. Thank you,
Thank you.
thank you.
Response, please.
Good morning, Chief Justice Gonzalez, and may it please the court. My name is Lauren Danskin, and I'm an Assistant Attorney General representing the State of Washington, Department of Children, Youth, and Families. The department asked this court to affirm the orders on dependency and disposition for two reasons. First, because substantial evidence supported the trial court's finding the AC was a dependent child, its consideration of hearsay evidence did not materially affect the outcome and was therefore harmless.
So if anytime there's substantial evidence, the court can hear inadmissible hearsay, that seems to be what the outcome would be under your analysis.
So, Your Honor, the outcome would not always be that way. If the inadmissible hearsay evidence, if the admissible evidence was not sufficient enough to
I'm
support
saying,
the
let's say
outcome.
there is sufficient evidence. That's where I'm starting. If there's sufficient, you posit, isn't it?
Unless the hearsay evidence went to something else, for example, credibility. So in the Gower case, this court found
So
that.
yes, the court can admit as much inadmissible hearsay.
Else, for example, credibility. So in the Gower case, this court found
So
that.
yes, the court can admit as much inadmissible hearsay as it wants to, as long as there's already been sufficient evidence,
Yes, Your Honor, although of course the.
an inadmissible hearsay.
It did, Your Honor, but there is a distinction in terms of, the department acknowledges there was a substantial amount of hearsay evidence that came in at this trial. But in terms of what the court relied on in making its ruling, it was a very small amount of the court's ruling that was based on that hearsay evidence.
Well, whether it's,
In its ruling, it was a very small amount of the court's ruling that was based on that hearsay evidence.
well, whether it's linked to the constitutional right to parent or simply the statutory language that requires inadmissible hearsay not be considered, what's the remedy then if it is admitted?
So, Your Honor, this court's harmless, but the test in order to reverse a trial is that there be prejudice based on the error. And so that's where this court can conduct that harmless error analysis, determine if the admission of that hearsay evidence was on the error. And so that's where this court can conduct that harmless error analysis, determine if the admission of that hearsay evidence was prejudicial to the extent that it affected the outcome. And if it is,
I'm sorry to keep interrupting, but if the prejudice analysis is simply, was there sufficient evidence, and if there was, it's not prejudicial, is that really a meaningful prejudice analysis? Because it goes back to my previous observation that your test just means if there's sufficient evidence, then the hearsay can come in.
evidence, for example, if it went to credibility. So in that case, you could weigh the substantial evidence that was admissible and find that there was still an error because the inadmissible hearsay evidence, undeniable evidence that was admissible, and find that there was still an error because the inadmissible hearsay, there would be substantial evidence in a dependency case, but the error might not be harmless for some cases where there would be substantial evidence in a dependency case, but the error might not be harmless for some other reason.
So it's not sufficient evidence, we're looking for substantial evidence.
So, Your Honor, it's whether the standard that the Court of Appeals applied in XT, and that's consistent with this court's other holdings, admissible evidence. That's the standard that the Court of Appeals applied in XT, and that's consistent with this court's other holdings, mainly in the criminal context. And everybody talks about, for instance, the court found that had the detective's testimony not come in, the state's case would not have been sufficient to support the accomplice liability. So it is based on a substantial evidence.
Isn't there a different standard in civil cases? And do you think a civil standard should apply in this case, or do you think the criminal standard should apply? And is there a difference?
So, Your Honor, I don't think there is a difference.
Should apply in this case, or do you think the criminal standard should apply? And is there a difference?
So, Your Honor, I don't think there is a difference. The question is really whether the error was a constitutional or a non-constitutional error. This was a non-constitutional error, and so the court can apply the same non-constitutional error analysis applies in the criminal cases, which is whether or not there's a reasonable probability the outcome of the trial would have been harmless error, which is whether or not there was prejudice. And not every case will the test be whether or not there was substantial evidence. In other contexts, for instance, ineffective assistance, will the test be whether or not there was substantial evidence. In other contexts, for instance, and I think the court can apply the same test whether or not it's a criminal case or a civil case. And on that vein, Your Honor, touching back.
Excuse me,
I'm sorry, Your Honor.
Are we only here because?
Case. And on that vein, Your Honor, touching back.
Excuse me.
I'm sorry, Your Honor.
Are we only here because apparently you don't disagree about what standard to apply, you just disagree with opposing counsel about the application. Is that correct?
I think that is correct, Your Honor. I don't think there's any dispute that there was an error here. I don't think there's any dispute that this court should then consider whether or not the error was harmless. And I don't think there's any dispute that the reasonable probability the error materially affected the outcome is the analysis this court should make. I think there might be a dispute about whether or not the court can resolve that question by weighing the substantial evidence once you've excised the inadmissible evidence. But I think truly the question before the court here is whether this error in this case was harmless based on these facts.
Can I ask a follow-up about, so there's some argument that would suggest that there might be different outcomes if we look at a substantial evidence test versus this materially affected test. And I will say that in XT and in Burgoyce, they're framed somewhat differently because the question is whether the error materially affected the court's decision, not whether here's my basic question. Whether it be a criminal case or a civil case, when we're looking at the prejudice from error, don't we evaluate whether the error tainted other things? I mean, would you acknowledge that if the evidence at the prejudice from error, don't we evaluate whether the error tainted other things? I mean, would you acknowledge evidence, including credibility determinations, that regardless of whether we could excise other admissible evidence, including credibility determinations, that regardless of whether we could excise it and just look at, kind of shake the pan and see what's left, regardless of that, if there's a taint, that's reversible error?
So, Your Honor, I disagree that if there's a taint, there's reversible error. That comes in the criminal context where there's been an issue where the prosecution has not turned over all the evidence to the defense. So in the Goyle case, for instance, the court uses.
I'm sorry, I didn't hear the beginning of your sentence. Could you say it a bit?
Oh,
You disagree?
I disagree
Justice
that.
Stevens.
I disagree that tainted is the analysis, whether or not it was tainted, because we're still looking at whether or not it materially affected the outcome. So I agree, Justice Stevens, if this evidence did go to credibility in this case or any other case, that we might need to do a different analysis over and above the substantial evidence
Well, it would be
test.
just applying the analysis. Wouldn't the
Yes.
question in any case be whether the erroneously admitted evidence materially affected the outcome? And I suppose really what I'm asking is, couldn't one measure of that be, well, did it weigh heavily on, for example, credibility determinations, which to me equates to like a taint. I mean, we talk in the Chapman standard where it's different, prejudice is presumed, it's a constitutional error, the burden's on the state to prove harmlessness beyond a reasonable doubt. But we look at the overwhelming untainted evidence, so a taint matters. And that's, I guess, what I'm getting at is, isn't the materially affected standard sort of getting at, well, did the error have a spillover effect? Because if it did, I don't know why we would just look at the evidence that remains once we excise the hearsay.
So, Your Honor, I agree. If the evidence goes to credibility, the court does need to assess that and determine whether it materially affected the outcome. I just disagree that it would only require a taint to determine whether or not that did materially affect the outcome.
Didn't it go to credibility in this case? I mean, the whole thing was based on whether the judge believed the parents' testimony, and they were cross-examined based on the hearsay, and you had them denying much of it. So I thought credibility was exactly what the trial judge was deciding here.
So, Your Honor, I guess I would say three things to that point. One, in terms of the statements that the parents disagreed with, a lot of the statements the parents disagreed with, for instance, whether the father had complete control over the mother, the evidence to support that assertion did not come in through hearsay. It came in through the father's own prior out-of-court statements. So that was not hearsay. He was rebutting his own prior statements.
So it was not hearsay as to him.
It was not hearsay as to him, Your Honor.
There's two people in front of the court right now.
Yes, I agree, Justice Gordon-MacLeod, and I think when we're looking at the mother, we're also looking at her in conjunction with the father, because they did intend to parent together. They held themselves out as a couple, and
Yeah, but you were talking about.
Chief Justice Gonzalez, in terms of the hearsay evidence here, so of course there was this parent's own statement, the father's own statement that would not have been considered for hearsay here. So of course there was this parent's own statement, the father's own statement that would not have been considered for hearsay purposes. And then in terms of credibility, even if we ignore the hearsay evidence that came in, there are the father's own statements which could also have gone to credibility. For instance, he denied ever making threats against the caseworker. Caseworker testified that she saw a video of him. So although certainly some of the hearsay could have been considered for that purpose, when we look at the court's findings, the findings that really were based on hearsay was that the mother had banged her head against the wall in frustration. The findings that really were based on hearsay was that the mother had banged her head against the wall in frustration. There's no non-admissible evidence that supports that, and that the baby's cord was potential evidence.
Counsel, I want to back up here to some of the factual.
Supported by substantial evidence.
Counsel, I want to back up here to some of the factual, to a couple of factual questions with regard to the timeline. So how long has this child been in out-of-home placement?
Your Honor, my understanding is at this point, the
Point, does the statute require the state to file termination?
so Your Honor, once the child,
And at what point does the statute require the state to file termination?
so Your Honor, once the child's been in out-of-home care for the last 15 of 22 months, the state is either required to file the court is required to either order the state to file a termination petition or to find good cause that a termination petition should not be filed.
So that's basically where we are at this point, factually correct? in
Yes,
terms
Your
of-
Honor.
All right. Tell me then how this court could possibly find.
So Your Honor,
Because if the findings that lead to dependency result in the child being in out-of-home care for such a period of time that then the state is required to file, result in the child being in out-of-home care for such a period of time that then the state is required to file termination. And I don't know what the parents have or have not done in that court. With a reasonable question about what the standards of review are, whether they were here to this court. With a reasonable question about what the standards of review are, whether they were, whether the standards were properly applied here. Time has passed to the point at which termination is now either required or, as you said, good cause has to be found. And of course, time passing with a child this age also means that the child has developed connections to out-of-home placement, whoever's providing that out-of-home placement. Am I correct on all of that?
yes, Your Honor.
All right, so with that as the basis, I don't understand how you can take the position that any of what happened, whether you're talking about dad or mom, can be held to be harmless. So tell me how you view that it is.
But that is not the analysis the court is making when it's determining if the error was harmless. The harm the court is looking for is whether it impacted the outcome of the trial. And so in terms of the harm the court is looking for is whether it impacted the outcome of the trial. And so in terms of the harm this court needs to assess, that's the harm. And then, of course, I would just indicate that the out-of-home placement, that's a dispositional issue, so that wouldn't go to the dependency finding. And of course, the dependency finding doesn't necessarily lead to a termination of parental rights. The parents could have requested a return home of the child, could have engaged in remedial services and effectuated that. So it does not necessarily, a finding of dependency does not necessarily lead to termination or to an extended out-of-home placement for a child.
Can I ask you a follow-up about, a question came up to opposing counsel, I believe, Mr. Steed, about if the court were to conclude that the error in the admission of the hearsay was not harmless, what result follows from that? He said vacate entirely the dependency, return of the child, or start of further proceedings need to commence from step one. What is your answer to that question?
So, Your Honor, I'd largely agree with Mr. Steed. If this court reverses the trial court's dependency finding, that equates to a denial of the dependency petition, which results in immediate dismissal of the dependency and, of course, return of the child to their parents. If this court were for any reason to require additional clarification for the trial court as to which of its findings were supported by admissible evidence, of course, a remand might be appropriate in that case, but if this court were to reverse, that would be the outcome.
Counsel, my question has to do with going back to a question that I think the chief had posed, and that really looks at the outcome. What's the rule in terms of what are we saying to trial courts is you can just, especially because these are really tried to the bench only, you can allow anything to come in. Just bring it all in, and the judge is going to segregate this, so don't worry about it. That the rules really don't matter. I'm worried reliable what goes to credibility or not. I mean, do we send a signal to the trial courts? Doesn't matter. Next thing you know, it's the same thing in family law. Doesn't matter. Bring it all in because we know you can segregate it. Doesn't matter. Next thing you know, it's the same thing in family law. Doesn't matter. Bring it all in because we know you can segregate it.
So, Your Honor, absolutely, the department is not asking for that outcome. Certainly, the department wishes for this court to rule that hearsay remains inadmissible at a dependency fact finding. There's no dispute about that, and that it would be error for the trial court to consider it as it did here. But I think the court to find this error harmless, one, it will be limited to the very specific facts of this case. Of course, dependencies are extremely unique. It's unlikely you'll ever see this constellation of facts again. And here and in all bench trials, we do have an advantage over a jury trial situation in which we can see what the trial court relied on in making its ruling. They issue an oral ruling, they issue a written ruling. That's why we can see that the trial court relied on hearsay in this case. So there is a check there, and that we will be able to determine whether or not the trial court relied on inadmissible evidence. And of course, there's a strong presumption that trial courts do not do this. Certainly, the expectation would be that this would be outside of the norm.
Though to some extent, when we engage in a harmless error analysis, it sends a message of, no harm, no foul. I mean, it does influence behavior. I mean, at least that's been discussed over the years in any number of contexts, including, the prosecutorial misconduct standard, et cetera. So can I ask this? If one thing that concerns me about the way the cases are written is that they fall within the longstanding substantial evidence description, but then we see, at least coming in the XT case, citing Burgoyce, not a dependency case, did the error materially affect? And so I'm still not understanding entirely your view of how those two things align, because I can absolutely see that if you look solely at whether excising what shouldn't have come in, is there substantial evidence to sustain the outcome, you might answer that question differently from the question of did the error in reasonable probability have an effect on the judge's decision, this judge's decision. The answer to those two questions might be different, and yet those two articulations are contained in the exact same cases. So the cases must not regard them as inconsistent. So maybe you could help us understand how you see those folding together.
Certainly, and I think they're not inconsistent, but that's not always going to be the test. So I think the test is always for a non-constitutional error, did it materially affect the outcome of a trial? Depending on what the error is, the court could, in some circumstances, particularly when we're looking at an evidentiary error, apply a standard where we look at this, whether or not, once you've excised the inadmissible evidence, the remaining evidence is sufficiently substantial to support the trial court's finding. There will be other cases where that same materially affects the outcome standard applies, but that substantial evidence test would not answer that question for the court. So in cases where it was an ineffective assistance of counsel issue, for instance, in the Estes case that my opposing counsel cited too, there the problem was that the defense attorney did not understand that a weapons enhancement would lead that to be a third strike offense, and so that impacted their ability to engage in negotiations or to engage in appropriate questioning at trial. So there, because of the nature of the error, a substantial evidence test would not be appropriate. You see that also in the Koiakis United States Supreme Court case, where that would not be the appropriate test because of the nature of the error. So I think it's the nature of the error that determines what the applicable test would be underneath that material effect on the outcome standard.
So
May I follow up on that briefly, and then Justice Gordon-MacLeod has a question. It seems to me that the standard is a little bit vague, to be perfectly frank, from reading the cases that Justice Stevens just cited and even reading the briefing in this case. But it also seems to me that that's because sometimes we care about the nature of the right that's affected, and that we consider that when we decide the outcome in a case and how carefully we look at it. I'm not sure that that's written anywhere, or that a different analysis than if it's just a property right that's at issue. Am I right or wrong about that?
So, Your Honor, my take on that would be that the things that are important are the type of error, so because that impacts the type.
Right or wrong about that?
So, Your Honor, my take on that would be that the things that are important are the type of error, so because that impacts the type of test that can be applied. And then, of course, as to Your Honor was touching on this earlier about what the standard, the burden of proof is below. So, of course, if we're looking in a criminal context, we'd have to determine that the determination is clear, cogent, and convincing. So I think those are the distinctions that might impact the way the test is applied.
Thank you. And Justice Gordon-MacLeod has a follow-up. You may go over time.
I'll pass, thank you. It was covered.
Right,
May I
then-
ask a follow-up?
Yes, you may.
You want to ask a follow-up to yours first?
I was just going to ask her to summarize the relief she desires, but first you should ask your question.
Thank you.
Her to summarize the relief she desires, but first you should ask your question.
Thank you. I'm a little troubled about a couple of things you said in response to, I think, Justice Stevens' question, where you said that the court was unlikely to see this specific constellation of facts again. And I think you were saying that because, each dependency is different. The reasons children are removed from their parents are different. Are you saying then, and the stage we're at now in this case, really only apply to one case and don't apply to other cases?
No, not at all, Your Honor. What I was indicating is that because
Only apply to one case and don't apply to other cases?
No, not at all, Your Honor. What I was indicating is that because there's no dispute about the rule in this case, the court's opinion in this would be a reaffirming its longstanding precedent. Whether or not there was error here is likely to only impact this case because of the unique facts of this case.
So that's troubling to me because it sounds like, maybe I'm repeating myself and you can clarify it for me. But you also said that what the court did here was outside the norm, which, having been a trial court judge and done these kinds of hearings, I just saying, well, the rule is applicable from case to case, but since they are so different, it's not really applicable from case to case.
So, Your Honor, the rule applies
to case, but since they are so different, it's not really applicable from case to case.
So, Your Honor, the rule applies in all of the cases. The point I was making is whether or not this case, whether or not the admissible evidence in this case is substantial or not is unlikely to be repeated across other cases because the specific evidence in this case is particular to this case. But I agree the rule has universal. Thank you, Your Honors. The department would ask this court to affirm the orders on dependency and disposition. Thank you.
Thank you. And in rebuttal, you may have 4 extra minutes to make your argument. Thank you. And in rebuttal, you may have 4 extra minutes to make your argument.
Thank you, Your Honor.
Counsel, I'm trying to understand where, but rather the application of the standard. Is that correct, or
I
is
think
there a
that is
bigger disagreement?
I think that's partly correct, Your Honor. I think it's how this court applies the standard and when that standard is applied, what the effect shows in this case. And that is when that standard is applied, what the effect shows in this case. And that is the real nuts and bolts of this case, is that the effect of the impermissible hearsay materially affected the outcome of this case in a number of ways. First of all, it was emphasized repeatedly by the department in closing argument throughout the case. It was explicitly relied upon by the trial court's findings. As a result, we can't say that the trial court would have reached the same conclusions that it did here without that inadmissible hearsay.
Do you see a role in this analysis for?
I agree that that is the test for this court, is whether, if we remove the hearsay, whether the remaining evidence is substantial. That is not the test that we are advocating for. That is not the test that this court has applied in the past.
Well,
remaining evidence is substantial. That is not the test that we are advocating for. That is not the test that this court has applied in the past.
Well, I thought I heard the state arguing that they agreed that the question was whether the erroneously admitted evidence materially affected to see whether that was sufficient to support the trial court's finding. Remaining that's untainted to see whether that was sufficient to support the trial court's finding. Where is it that you disagree?
Well, again, I disagree with what the court does after it analyzes what is remaining after the hearsay. Our argument is that whether or not it is trivial in conjunction with the evidence. Well, and that is part and parcel of the question of whether or not it is trivial, Your Honor. And
wouldn't it be a better materially effective?
Well, and that is part and parcel of the question of whether or not it is trivial, Your Honor. And
wouldn't it be a better test to say, did it materially affect rather than was this evidence trivial?
Yes, but again, I think that's all part and parcel of that test. Whether there's a reasonable probability that it materially affected the outcome of the case is based on what effect did it have on the case, notwithstanding the evidence. credibility, for example. The department here repeatedly emphasized that if it undermined credibility, then it would materially affect the case. It did here, Your Honor, because that hearsay was used to weigh my client's credibility about the events that did or did not happen versus the social worker's testimony about events that did or did not happen. And in particular, the department cites to the social worker testifying about threats that were made against her versus my client's denial of those threats being made. That is a credibility determination. The alleged evidence of that, which was contained in videos, those videos were not admitted, nor was any substantive evidence admitted in this case. No exhibits, no documents, nothing. This case was based on credibility. Which party is telling the truth? And if hearsay is used as a basis to undermine that credibility, well, then it has materially affected the outcome of the case.
Though would you agree that well, and I guess I'm premising my question on the understanding that you're not asking us to overrule a fairly long line of cases that frame this in terms of a substantial evidence case. Am I correct about that?
Well, I think, again, Your Honor, I'm struggling with the answer to that because I think there's some disagreement here about that test. We don't.
Are you asking us to overrule cases that say that's the test?
That substantial evidence, that you analyze non-hearsay evidence for substantial evidence?
That you analyze, that you look at the error ones?
Yes. Well, we're asking you to overrule the cases which say that once we examine the remaining evidence, is the evidence substantial to support the dependency finding?
Is it fair for me to say I did not see that in your?
We examine the remaining evidence, is the evidence substantial to support the dependency finding?
Is it fair for me to say I did not see that in your brief?
I would disagree with that, Your Honor. We've repeatedly argued that the test is not a sufficiency test. We've contended that whether the erroneous admission of hearsay in no way affected the outcome is different than whether the remaining evidence was sufficient to support the dependency finding. We do take issue with that.
Okay, so which cases need to be overruled?
Well, Your Honor, a number of cases. The cites are in my supplemental brief, but this court just recently affirmed 3 weeks ago in MR that is the appropriate test. That the test is not a sufficiency test once the hearsay is removed, but whether or not there's a reasonable probability that it materially affected the outcome.
Well, isn't that part, wouldn't you want to see how strong the remaining evidence is? I mean, it seems to me these are interwoven at a minimum.
I'm sorry, Your Honor, what is interwoven at a minimum?
Whether there's sufficient evidence.
Yes, and they're not mutually exclusive in that respect. I mean, this court can, find that evidence is insufficient when hearsay is excluded, but alternatively, this court can also find that, the admission of hearsay nonetheless materially affected the outcome of this case, regardless of whether the evidence was sufficient.
So there's a role to play.
There can be a role to play, Your Honor. We're suggesting that isn't the appropriate standard that applies, but certainly they are not mutually exclusive. They can be, analyzed both in the same context.
Is it fair to say that there'll be cases where there's a whole bunch of hearsay and that some of that hearsay is really bad? And there'll be other cases where there's just a little bit? Both of those things matter in when you're deciding whether
They do. I think that evidence is the point I'm trying to make, which is the substantial evidence, sufficiency evidence is a different question than whether or not the point I'm trying to make, which is the substantial evidence, sufficiency evidence is a different question than whether or not the evidence materially affected the case. Because a case can be materially affected by the admission of hearsay in a number of ways. Credibility, cross-examination, all those types of things can materially affect a case regardless of whether the evidence was or was not sufficient.
So can I ask you the same question? Because that makes good sense in a lot of ways. And I think about in the Chapman standard, we talk about overwhelming untainted evidence. Do you think there's any connection here? That if the court says, well, but this error materially affected this other evidence, so then wouldn't we excise that as well? We've got to look at what remains that isn't tainted. I mean, maybe taint isn't the only test, but that seemed to be sort of what you're getting at.
I guess to a certain extent that's true, Your Honor. Materially affected is such a broad term that this court needs to consider, such as this, for example, where there is no documentary evidence. There are no exhibits, nothing else. And it really does, in a case such as this, for example, where there is no documentary evidence, there are no exhibits, nothing else, and it really does boil down to a credibility determination. excising that evidence, you can't show that it wasn't materially affected because that hearsay played a role in the court's credibility determination, which then directly impacted, whether a dependency and disposition order was going to be entered. A different outcome might result in a case where there is documentary evidence, where there is a certain admission. So there is a certain case-by-case analysis here, but the question this court needs to resolve is, how are we going to apply that test on a case-by-case basis?
Please briefly summarize the relief.
Absolutely, Your Honor. We are asking that this court reverse the dependency, dispositional, and placement orders. Thank you.
Thank you for your briefing and your argument. The case is submitted. We are in recess for 10 minutes.
All rise.